that Waqf has the ability to receive endowments from non-Muslims, and its conduct also has the effect on the rights of non-Muslims, it only made sense to have the presence of non-Muslims as part of the Waqf board. The manner in which the Waqf board existed prior to this, and the manner in which these provisions facilitated the assertion of rights by members of one community, had a direct bearing on the fundamental rights of other communities as well. If we were to go by the existing statute and corpus, the primarily concerned.
Let's get a little history as far as the Waqf Act is concerned. We'll go back a little bit and we'll also try and understand what changes in the new law.
The legislation was brought about for the very first time in 1995 and then subsequently amended in 2013. It had certain provisions which have an impact on the following aspects, which are the specific issues that even the current bill addresses: creation, consolidation, management, composition of the tribunal, effect on third-party rights, and finally adjudication. These are the 6 broad heads under which I would like to address or compare the legislation as it stood prior to this amendment and the legislation that's just been passed by the legislature with the assent of the president. The problem with the pre-existing legislation was the serious impact on third-party rights, creation of Waqf through user and not just through creation or endowment as we typically understand it. 3, the broad impact of these 2 provisions on the rights of third parties, especially religious communities. These, I think, were the broad problems with it. And secondly, the ability of oversight either by the state or even by the higher judiciary, so to speak, was practically absent. These are the areas where the current form of the legislation has managed to plug in some of these holes, wherein the problematic provision of Section 40 has been repealed. Then the composition of the Waqf board has been altered to have the presence of both non-Muslims as well as women as part of Muslim members, along with certain representations from the government itself. Considering that it has that Waqf has the ability to receive endowments from non-Muslims, and its conduct also has the effect on the rights of non-Muslims, it only made sense to have the presence of non-Muslims as part of the Waqf board. 2, apart from Sunni and Shia Waqf boards, the possibility of diversity in representations from other Muslim sects, such as the Aga Khani as well as the Bohra sect, have been created specifically in this amendment. And the appeals to High Court from any decision of the Waqf tribunal, I think, is a stellar or salutary provision. If I had to go back with one, perhaps feedback or constructive criticism of the...
And that was the much needed amendment that has been made. Because if you cannot repeal to the courts of the country, then what are you doing? What rights do you give to your citizens? At least, like, whatever decision has been made by the Waqf board, it should be appealable in the normal court system and not just the Waqf tribunal.
Of the legislation that has been passed is what does it do?
नाम भी ऐसा बोला नहीं जाता, Waqf.
With respect to pre-existing claims where the Waqf board has extended a claim to properties that perhaps don't belong to it, and what does it do to these outstanding old claims? That question has been left almost untouched, and perhaps that should have been addressed. But for whatever it's worth, I think a significant surgery has been undertaken of the legislation as it stands.
Absolutely. Now let's talk about management and how the Act helps really in managing managing the Waqf properties, and what happens really as far as the Waqf board is concerned, and what are the larger implications really?
See, one of the things that I'll just build on Mr. Sankla's point on the issue. So you have to consider one thing. This is one of the subjects where property jurisprudence meets religious endowment. Now, let's address this from a fundamental perspective.
For a very long time, I have been away from politics. I have been reading mostly fiction books, which talk more about philosophy and literature than the current politics or the history of politics per se. So this video in itself is a learning source for me, because now I get to know what all amendments have been made in the Waqf Amendment Act. So I'm learning with you guys.
Does the central government have the power to or the central parliament, the union parliament, does it have the power to legislate on the subject? The subject falls under entry 28 of the concurrent list, where all charitable endowments typically are accommodated, and therefore both the state and the center have the power to pass laws. And for a fact, the center's power will prevail under the doctrine of colorable legislation if there's something contrary to it. Now, the second thing that you have to consider is when it comes to property jurisprudence, even if it is treated as a matter of fundamental rights, the manner in which the Waqf board existed prior to this and the manner in which these provisions facilitated the assertion of rights by members of one community had a direct bearing on the fundamental rights of other communities as well. Assume for a moment.
Of course, of course. If you just go on a rampage, taking properties from everywhere, then everybody is gonna get affected. But I guess he has a more deeper point. Let's listen to him.
If under conventional property principles, somebody had to lay claim to your house, he would have to first of all show that the property belonged to him, that there is some title deed which has been issued in his favor, and he would have to satisfy some de minimis principles to explain why he has the right to assert ownership. In stark contrast, the Waqf Act was a serious anomaly where it expected the person on whom the claim has been made to prove that no claim lies and that the property belongs to him or her for that matter. Now, these are certain fundamental aspects which are violative not just of those evidentiary principles or burden principles that we take for granted when it comes to conventional property jurisprudence. It also overturns the right of property of third parties. So if somebody truly wants to characterize this entire issue as a question of fundamental rights, it's as much a question of third party rights as much as it is a question of the rights of members of one particular community. Two, if you look at the global map in terms of how these Waqf Acts or these legislations have been managed or administered in even Muslim countries for that matter, or countries which are Islamic republics, you will see that there is a very clear state oversight for multiple reasons. One is to prevent mismanagement within, which means you give it in the name of the community, but at the end of the day, the community does not stand to benefit for whom the property has been endowed. Or assume for a moment that rents are supposed to be collected from certain properties, which are Waqf properties and which have been leased out, but no rents are being collected. These are issues that the government has a legitimate right to step in and take a look at. No amount of minoritarianism can take away the power of the parliament to create a legislative oversight and an executive oversight over management of such vast swathes of land. If you were to go by the existing statistics, you're looking at what, 32 lakh acres.
Yeah, but people don't care, no? The moment government talks about anything related to minority, then this whole activism, this whole ecosystem will kick in, and they will just not listen. They will just start with their rhetoric of how the current government hates Muslims, how it wants to trivialize the real problems of Muslims, how they want to make Muslims the third class citizens of the country. So this all machinery kicks in the moment you just speak the word or talk about something that is related to the minority.
Acres. That's a massive number in terms of land corpus. And I don't know of any body other than the Union of India and perhaps the Indian Railways, which has access to this kind of land corpus. And if it has rights, if it has an effect on, let's say, the rights of members of the community as well as third parties, I don't think politics is the question here. The question is of legitimate rights and concerns. Now, coming to the question of management, what they have done here is also to create a public portal where the proceedings of the Waqf board and any decisions taken by the Waqf tribunal, so to speak, can be made public for third parties to have access to it. And if any third party rights are actually affected by it, they can actually approach and say that this should not have happened in the first place. Now, this is not an aberration. Any lawyer worth his salt will tell you, if parties A and party B are fighting with each other over a certain property, and in the process of that fight, the court ends up passing a certain order that has a direct impact on the rights of property C of a third party, then that particular person has the right to enter proceedings and say, if these two people are fighting, how did you pass an order which has an impact on my rights? But that is possible only if that order becomes public, so that people know that.
Oh, so the whatever proceedings that were happening were not made public also. That's That's very weird, because every decision that's been made in courts is made public, because then it can be used for as precedents in other cases, or you can plan your affairs accordingly, because you know that so and so rulings have been made in previous prior cases, so you know what's the law on that matter. So that this is very bizarre, I would say. So any as more details come to light, this whole thing keeps on looking more and more bizarre.
Such an order has been passed. But if the proceedings of the Waqf board or the tribunal are quasi-confidential, with people not knowing what exactly is happening there, how do you then enable transparency and how do you enable access to justice? So these are certain aspects that they have addressed. Also, what they've done is the government has the right to appoint non-members or non-Muslims as part of this particular committee, which ensures that there is some diversity of representation. I'll give you a simpler comparison. People can say, can a non-Hindu be appointed to, let's say, the temple management board? In such a situation, how can you appoint a non-Muslim to the Waqf board? The difference is the temple management board primarily concerns itself with the management of the temple, whereas the Waqf board is looking at real estate and not the running of the mosques. That's point number one. Point number two, there is a specific legislation wherein the government actually extracts a cess from temples for the services, so-called services it provides in terms of management of temples. That is not in the situation when it comes to Waqf board here.
Right.
The government is not doing any kind of rent seeking or rent extraction from this body. All it is saying is the manner in which you've been operating over the last few decades, so to speak, comes at the expense of transparency and third-party rights. Let us put that house in order so that some kind of balance is struck between your community rights to endo properties in the name of your deity and what does it do to third-party rights. I think that's all there is to it. To make this an issue of minority rights, according to me, is to do injustice to the balance with which this entire issue has been addressed.
All right. So it's all about transparency is what J Sai Deepak is suggesting. It's all about better management. It's all about bringing things under control. All right. And you addressed the issue of non-Muslims being part of the Waqf board. The issue of government oversight. Now, this is another aspect that has been spoken about quite often, especially members of certain sections of society and politicians as well. Mr. Sankla also touched upon that particular aspect, brought in the example of Puducherry too. Government oversight. Why is this really such a contentious issue and such a big problem?
Okay, I'll answer this question differently. Assume for a moment that the pontiff of a particular mutt or a seminary passes away and the mutt is in possession of, or it has at least thousands of crores of property in its name. The government actually has the right to step into the picture to see that that particular money is not misused or siphoned off or pilfered away. This is in the context of a private seminary, which is protected both by religious rights as well as privacy of property. In the context of the Waqf Act, massive swaths of land are being given away in the name of the Waqf. The entire regimen of administration was such that sunlight would barely manage to enter the portals of the Waqf proceedings. You would not know whose property is being taken. You would not know what are the principles that are being applied. And since the burden of proof has been completely turned on its head, nobody has access to any kind of...
If things are happening so much behind closed doors, then you know that something's fishy. Because if it's such a huge body which concerns such big public matters, then its proceedings, its functions, its laws should be made public completely. Like nothing should be hidden, which is something that happens with all the institutions in India. So just the fact that so many things are happening behind closed doors should be very alarming to everybody.
Principles of natural justice to say, if you assert your rights with respect to property over which I have documents, the onus is on you. And the example that Mr. Sankla was giving was of a 1400-year-old temple suddenly being claimed in the name of the Waqf, where the temple and the faith that it belongs to, I mean, they far predate the faith to which the Waqf community actually belongs, to the Waqf board actually belongs. These are the kind of instances that you're actually looking at. So as far as I'm concerned, the track record of this entire tribunal has been one of tribalism. unfortunately, the tribunal functions like a tribe. And therefore, the presence of those parties who have been affected in the long history of the Waqf board and the Waqf tribunal is legitimate way of addressing that particular issue. Now, you make the proceedings public. You also set an even playing field by ensuring that traditional principles of property are applicable to it, and there is a representation from across the board. How does that in any way affect if you have nothing to hide? If you have nothing to hide, you should not have a problem with the presence of somebody else. This is, although this may be a religious endowment, it so happens that this religious endowment can come at the expense of third-party rights. To just build on what Mr. Sankla said, Waqf by user is such that you can claim certain properties through a user without even showing what is the kind of user that you're looking at, whether principles of adverse possession of property actually apply to you. Do you at least satisfy those principles to say that although somebody has not endowed it in my name, through user it has become mine? What has happened in the process? Mazars have been created, shrines have been created overnight in places of either religious significance or of strategic importance. Please take a look at the latest instance where suddenly you can see a lot of green mazars cropping up around sensitive locations such as the upcoming Mumbai airport, okay, or around the Mumbai airport. When you look at this, you end up wondering whether this was meant to facilitate ownership of community property for the benefit of the community, or does it have other implications for third-party rights as well as national security, dare I say it, because if something is happening without scrutiny, and when scrutiny or simple transparency is seen as an attack on fundamental rights or religious or the religious identity of a particular community or the religious rights, then I must say that you're using legitimate provisions of the Constitution in an unfair way to shield scrutiny of what exactly is going on. I refuse to buy the argument that a community or a body which is sitting over a land bank of 32 lakh acres can operate without the oversight of the state when it has consequences for national security as well as for third-party rights. I refuse to buy that argument. This is not a communal argument. It's a perfectly justified argument. When Satyam was in doldrums, the government stepped in to say,
Also, let's see, there are always people with nefarious intentions. And when they see that certain big bodies or certain organizations function without any government oversight, then they try to take advantage of that situation. So even if certain organizations were established to do good work, but if that work is happening without any oversight or any kind of supervision, then definitely people with nefarious intentions will try to take advantage of that situation. Same thing happened with madrasas, and probably the same thing is happening with the Waqf board.
set the house in order and stepped out. If you can do this with a private company, if you can do this under Article 31A, which permits the taking over of even private property in the interest of public, what stops the government from putting in place a simple, better, transparent regulatory structure which ensures that there is more transparency in its operation? Has the government repealed the Waqf Act? Has it done away with the concept of a Waqf altogether? Has it taken away the right of representation of Muslims in it? Has it populated the tribunal with majority of non-Muslims? If the answer is no to each of these questions, really what are we crying about here?
Right.
I think that this legislation has been passed after extensive consultation and representation from across the board, from all stakeholders. Two, although I believe that this is a fantastic step in terms of what has been done, I am certainly of the view that more could have been done, particularly to set the house in order and to create an even playing field for all communities concerned in terms of perhaps addressing questions with respect to past ownership. Three, I genuinely hope that the judiciary approaches this from the perspective of applying the standards of conventional property principles and asks, what is it that has happened in the context of the Waqf Act, which requires judicial intervention? If all it has done is to infuse those very same principles which have been endorsed by the Supreme Court over and over again in multiple and thousands of property matters to religious property matters, should religious property matters be exempt from the application of conventional property principles? That should be the straightforward question.